atmosphere, including, of course, the international criminal court cases, the elections of 2013 and the petitions that followed thereafter, that it has been 4 good years, almost 4 good years of waiting. And I do not think there is any country in the world that has put a piece of legislation into a freezer for 4 good years, holding at bay all its promises that it held for the sector. And it is for this reason that we decided as a sector, as a leadership of the sector, to convene this high-level meeting so that we could get, one, to make critical decisions and resolutions that should see us moving forward. As you are all aware, not too long ago, on the 5th of September to be specific, none other than the Cabinet Secretary for Devolution and Planning did invite us, 5 of us from the Civil Society Reference Group, another 5 from the international NGOs, for a meeting, a consultative meeting, which meeting up to this day I would describe as one of the most momentous and fruitful meetings that the sector has had in recent times. And we had our brief moment of celebration, because the meeting culminated in an announcement that caught our attention also by surprise, because it was not something we expected. That the Cabinet Secretary signed, as we witnessed, a notice to the Office of the Attorney General for the gazettement of the commencement date of the Public Benefits Organizations Act. As you are all aware, this is our law. We are the originators of the Public Benefits Organizations Act. Its history is long and winding, dating back to 2009, when the Committee of the Wise, led by our own veterans that I see in this room, the likes of Esra Mbogori, the likes of Davinda Lamba, and many other activists of their generation, came together to chart a new course and legislative framework for the sector. This law, in our view, holds the best promise for now for this sector, because it will help streamline a lot of things that are currently not going on very well. It will help in speeding up registration with timelines. There's an appeal mechanism in this law so that anyone who is not satisfied with the decision of the Public Benefits Regulatory Authority can make an appeal to the Public Benefits Tribunal. We have a piece of legislation that, in our view, holds the best for Kenya to become the station of choice for people working in the humanitarian, development, and human rights fields. Of late, Kenya has been touted as the destination of choice of international conferences. We are saying Kenya has better potential in the region, in Africa and in the world, to attract more of such meetings. We recently saw the Ibrahim Moore Foundation moving Kenya slightly up the ladder in terms of governance, 12th in Africa, but we are saying Kenya has a potential to become #1 in the region if the Public Benefits Organizations Act can be put into use. We have witnessed, however, that there are certain dark forces, despite the goodwill of the Cabinet Secretary, that reside in the Ministry of Interior, that still live in the Office of the Attorney General, that do not want to see this sector prosper. And today, for me, I would not wish to be associated with this meeting if at the end of it, we do not come up with a resolution that, whether we are registered by the NGO Act or not, we must take a decision, and a firm one for that matter, to say we will want to do no business with NGO Coordination Bureau until certain changes in terms of personnel are made. That is something I'm looking forward to, because we can no longer be kept living on our knees when we have the potential to stand upright. The delays, I know, have affected our friends from the international community whose work permits have been kept in abeyance for more than 2 years. We saw recently a circular threatening to deny recommendations for our international colleagues that unless they demonstrate that the skills they bring into this country have no equivalent, then they'll not be given the work permits. Kenya as a country in Africa is one of those that has this largest number of citizens across the world. I'm not sure whether Kenya driving a taxi in New York has any skills that an American cannot possess. Yet these decisions are being made by certain people who did not go back to school in the afternoon, that we have allowed to mistreat us, to subject us to all these maladministrative actions. I think as a sector, as we meet here, we must also blame ourselves. That how did we allow this to happen? Yet we know some of the cobwebs hanging in the doors of some of these characters, intimidating us day and night. If the Constitution of Kenya 2010 remains the governing principal law of the land, Article 3 of that Constitution calls on all of us to respect it, to uphold it, and to defend it. The reason we have called you here today, and also for Kenyans, is to draw the line and say from this point henceforth, both men and women in this sector will stand to defend the Constitution. Because our freedom of association as enunciated in Article 36 of that Constitution is being threatened day and night. The NGO Coordination Bill has been turned into a toll station. People seeking to open a new account have to part with 4,000 shillings. Extremely illegal things, but which we have allowed to happen. We know that in the recent past, almost 1,000 organizations have been deregistered. Yet, Article 36 of the Constitution says that any law requiring registration of an association must provide that before that registration is withdrawn or withheld, there must be a fair hearing. Yet we have also come to being heard after the fact. This is unacceptable. And we must, as a sector, take a decision on that. Ladies and gentlemen, you all know the funding uncertainties that we face. The uncertainty with regards to engagement with the NGO Bureau, the leadership crisis crippling the self-regulatory framework, the realignment of activities that we have been forced to engage in, the uncertainty on work permits, the inability to engage the government on key policy issues. Yet our Constitution, perhaps in the whole world, is strongest on public participation. Kenyans can only participate in the governance and day-to-day management of this country through their citizen groups, of which we are an integral part. And therefore, ladies and gentlemen, as I conclude, I want to invite us to reflect, and very intensely so, on whether we want to continue with this path of homeguard regulations as opposed to facilitative regulations. We have an opportunity today to say that we want to put behind us this colonial homeguard approach to regulation that has been forced on us, and say we are no longer willing to lay our backs for those who want to fleece us of the little resources that we have had. I want to see the same valiance with which we have fought attempts to amend the PBO Act. I want to see the same anger I saw when Willie Kimani and colleagues were killed. That is the kind of valiance that this sector has been known for.